Hi, I'm Tom King, the founder of Toolkit.law, and I'm here with an attorney for whom I have a great deal of respect and who has done many other continuing legal education webinars with me. It's Serena Hudson with the law firm of Toombs Email here in the United States. In particular, we're in the jurisdiction called the state of Texas, but of course, Toolkit.law has an audience of the 80 plus countries with English-based legal systems. Serena, you previously did this help sheet for me about 3 years ago. I live off of it every time I do a mediation memorandum. Let's go ahead and get started on how to draft a mediation memorandum. Of course, this doesn't apply just to family law, but that's what you originally, the audience was that you drafted it for, correct?
Course. Yes, you are correct. And thank you. I can't believe that you've been using it for so many years. Yes, I mean it's always good to have a checklist when you are drafting a memorandum for mediation because it's the first time that the mediator is going to learn anything about your case. And oftentimes you've dealt with your case either, for a couple of days, couple of weeks, couple of months maybe. And so you know your case in and out, but you need to make sure you can explain it to other people so that they can really get in all the information in such a short amount of time and space so that they can know exactly what's happening. So when you are drafting this, you always want to start off with a few things. You want to summarize the case status, things like that. So you want to tell them what kind of case it is. You'd be surprised how helpful it is to know that either it's a divorce or it's child custody or things that are there. So because that'll change things. And you want to include causes of actions and claims. What is it that my client's wanting? What is it that the other client's wanting? What do I have to refute in their claims? You want to also provide your defenses, which is to refute their claims. So anytime there are defenses where the other side's saying, hey, I'm claiming this, and you're like, no, 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 that's not what's happening here. And this is why you want to make sure you include that too. You want to address that right off the bat. You don't want to make sure you want to make sure that you don't wait until the last minute to do that.
So
Um,
let's go ahead and jump into the help sheet.
yeah,
In
yes,
memorandum drafting, the first column you're doing is summarize the case status. Why don't you walk us through this column?
yeah, absolutely. So just kind of went over the type of case, make sure you include that, causes of actions, claims, defenses, just went over that. You'll also want to include a description of the parties, who's involved here. Depending on the case, you're going to have different parties. Sometimes there's going to be one on one side, one on the other. Sometimes there's going to be a bunch of parties on one side and one on the other, vice versa. So you want to make sure to describe all of them and give an overview of what their play and what their role is in here. Oftentimes, there's going to be a timeline that's going to be really important to a case. So providing key dates is going to be really helpful, especially for mediators. Kind of giving what I usually do in a mediation memo is at the very top, kind of give some key dates, kind of say, okay, these are the parties. If there's children involved, this is the child, that's date of birth, and then give the key dates when the case started, important events from before, key dates of what's happening during the case, if there's a hearing coming up or trial, which kind of goes into the next section of status of the case. Where are we? Are we at the beginning of the case, middle, or the end? Because that's going to change your entire strategy of how you want to handle something. If you're at the beginning of a case, some places may have what's called temporary orders or getting orders in place during the pendency of a suit versus final orders where you're pretty much wrapping up the case with a nice little pretty bow, hopefully. So, including in your memo on where the case is sitting right now can really help determine what issues there are that need to be addressed.
And also,
Um,
with the status of the case, how the other side is working with you or not
exactly. Yes.
working with you. What's the
Yes.
status of discovery? If your
Exactly.
jurisdiction in the 80 countries around the globe with English-based legal systems is discovery is part of your legal systems, have you requested things? Have they refused to give it to you? Have you had to go to the judge in a hearing and request sanctions and to compel them to produce discovery? I find those things are helpful for a mediator.
Absolutely. And quite frankly, I have a mediation tomorrow all day, and I was doing that, putting the status in there, and I realized about halfway through I forgot to put in there that we've done discovery and that we're missing some key things for the property division, so had to include those. So you're absolutely right. Funny you should mention that. So Also, what you want to include is kind of going back into this is any upcoming settings, as we talked about if trials coming up, or if you've got a big hearing coming up, you want to include that. Kind of help give the mediator an idea of, okay, maybe we should need to put a little bit more pressure on this issue, or maybe we need to back off on this issue because we need to look for, a trial further ahead. So putting those in there is good too. In our jurisdiction, we have what's called, or in some jurisdictions, maybe not just ours, but we have things called standing orders and injunctions, which are orders that are put into place pretty much right when you file. Whereas in other jurisdictions, you have to apply for these things. So having a understanding and telling the mediator of, okay, we're in this jurisdiction, we either have standing order or we don't, and we need injunctions to prevent people from doing bad things. And this is why. Including that is really important. That comes up a lot in our area of work pretty much all the time, every case really, for the need to have things to prevent people from doing bad things. Yeah. And then kind of wrapping it up on this section, any special circumstances. I mean, every case has its nuances. Some are going to be, some general things, but every case I like to say at least has some, specific things that you need to address or maybe not address, but if they do need to be addressed, make sure to address them because, again, you don't want to be halfway through the mediation saying, oh, wait, I forgot about this special circumstance that may change everything. Oh, let's start all over. You don't want to do that. So you want to make sure you and the mediator know about that and tell them. And then when you are drafting a mediation memo, play to your audience. Some people like to have a lot of detail. Some people don't. I find it very effective to only give a mediation memorandum that is only maximum 3 to 4 pages, 4 maximum. And the reason for that is it should not be a laundry list of every single fact in there. You want to make sure that your mediator is actually reading through it. It's meant to give an overview of what the issues are and all these things where you're summarizing it. But you also don't want to give them 20 pages because, quite frankly, I don't think they're going to read it. So you want to make sure that you're being effective in your drafting.
Which also gets to getting it to the mediator at least 24 hours in advance so they can read it. I can't tell you how many mediations I've gotten the memorandum like 20 minutes before.
That morning? Oh,
Tom, did you read my memo?
Yeah. When? Yeah. So yeah, again, and you were absolutely right. So my mediation tomorrow, very contested case. It's for all day tomorrow and I sent it yesterday. So I wanted to make sure that the mediator at least has a day to read it whenever her schedule allows.
Let's go ahead and go to the second column that you put together for us. Summarize the court admissible evidence. Get a sense of help convince the mediator, give the mediator some tools so that he can go in the other room and say, look, they're already prepared for trial. Here's their court admissible stuff. Sometimes I'll include an exhibit list and I'll include 6 exhibits, right? Right?
Yep. Videos are the best.
Videos are the best, especially in family law.
Yes. Yeah, absolutely. Because I mean, you're just as good as your evidence, And so especially when it comes to videos, when the other side is claiming one thing and you're like, nope, I can nip that in the bud right there. Here's a video to show otherwise.
Yep. Okay, so let's look at the burden of proof. So remember, you may have a mediator that mediates in a couple different areas, right? They may do civil, they may do family law, and you need to let them know what is the burden of the proof that works for you. Okay, tell them the burden of the proof. Put together your assets and your debts, and it's kind of a great segue for me to share on Toolkit.law. If you go to the numbers section of Toolkit.law, we have an assets organizer and we also have a liabilities organizer. If it's a family law case, go to the tools section and go to the divorcer, and whether or not they're married or not, it's an all-purpose tool. And in divorcer, you can summarize the child custody issues, you can summarize the paternity issues, you can summarize the property issues, you can summarize the spousal support or maintenance issues, you can outline if domestic violence has been involved, and you can turn all of this as an exhibit to your memorandum that you generate. And of course, if you go to suites, you're going to find all of this in the mediation suite, including when you go to mediator, and you're going to find the mediation memorandum generating tool. So you open up a case and you're going to be able to fill out all these tabs, the case tab, the pleadings, the basics, the details, and what your first offer is. And you attach all this other information that you got to organize. And what's great is now in the next month, Toolkit.law rolls out the ability to have your clients create a free account and they can share whatever they organized to you. So when you go to Toolkit.law with your clients, it's a free 6-month trial. And remember that and ask them to go to whichever calculator in our numbers section or tools, right? And again, you talked about great evidence. We have audio editors and we have video editors. We have PDF tools. It's because you want to make sure that your video is clean and crisp, or you blur out people that don't need to be in there. So we have all of these evidence organizing tools as well. But I digress. Okay, so back here. So in the column on the right, property, attorneys never do appraisals. I don't understand. Serena, I'm sure you do, but if an issue is going to be that they're going to split the house, or if someone's going to be awarded the house so that the other person can be awarded something commensurate, you either need to have an appraisal in advance, or you need to have an agreement that they'll each get their own appraisal and you'll take the middle valuation. That's how I solve it. I say the parties agree that each will get their own appraisal in the next 30 days, and the average of the two will become the appraisal. Okay? Account statements. Your attorney needs these. You need to organize these, and then you need to have a summary of the balances of each of these accounts with the last 4 digits of these debit cards, these checking accounts, these savings accounts, these retirement accounts, these pensions, these investments. You need all these account statements. The time to start gathering them is not during mediation, but I always, as a mediator, I always say, mediation is the best way to get discovery, because that's how lawyers use it half the time. Not you, Serena, not you.
No. Although I had a mediation this morning and I found some other things, and I'm glad I didn't send discovery before. It was on temporary order. So now I'm glad that I didn't, because now I will utilize it for drafting my discovery request.
There you go. Okay. So if you have reimbursement claims, it needs to be legit, and you need the statute, right? So what happens if it was a piece of property that the husband bought, then they got married, and then somebody gave them a house on the property to put on the property for free, and then they got divorced, but they put solar panels on the property during the marriage? Is that a community debt? Are they entitled to reimbursement? Every jurisdiction will deal with it differently. That's an actual case that I'm working on right now. So you have to have not only the reimbursement cases outlined, but you need the arguments to justify whether or not the reimbursement claim is legitimate. Okay? If you're dealing with custody, summarize and provide documents that help your client's claim. So have the school records that have academics, attendance, and behavior. If they do extracurriculars, summarize what they do. Do they do piano and karate? Hopefully not at the same time with the same instructor. Maybe what you're going to show is the other party is wearing the children out. They have the kids doing 6 different events on 6 different days. Summarize things that help you and hurt the other while being honest about what you present. Now, certainly no one ever says anything in a family law case that's stupid on social media. But if you go to Toolkit.law, in our video editor, you put in the web address of Facebook or of YouTube, it automatically downloads and converts the video file for you so you can organize it as evidence. It's actually really cool, Serena. You should go look at that.
I didn't know that. I'm gonna have to go look at that.
Yeah,
that's really neat.
Yeah, so if you go to Toolkit.law, you go to tools, you go to video editor, and there is the video online downloader for Facebook, Instagram, Snapchat, and YouTube. And you put in the exact web address right here, and then it instantly downloads the video and it converts into like 8 different file formats. Okay. Then you can see all the other things you can do. You can crop it, you can extract something out of it, you can increase the volume, you can add text before it or after it, all the things that basically you don't want to be an Adobe Creative Suite expert because we're really just modern legal professionals. We just need basic tools. And so we grabbed the top 25 or top 27 video tools and we made it suitable for legal professionals who are not technical. Anyway, so what if you're asking for something that's above and beyond what's normal? You need to help the mediator understand that while this is extraordinary, it's justified. Okay? If you're asking to get more, I'll give you an example.
Yeah, I was gonna say, give us some examples here.
So the one that I like, I have a case in which the husband and wife been married a number of years. All the children are adults, but one of the child is a special needs child at age 25. Never been adjudicated before. Okay. Your jurisdiction may or may not allow for child support of an adult who's not been found incompetent yet. Maybe this comes in your jurisdiction under probate or guardianship law instead of family law. So you don't ask for more for child support because it may not be available in your country. What you may need to ask for instead is a greater percentage of the community because you're going to be taking care of that 25-year-old with special needs for the next 20 years. And so you need to help people understand what the extraordinary relief is that you're asking for. There may be a special trust need. I had a case where the husband and wife had gotten divorced. They moved on. Husband had remarried, moved to Colorado, and the 17-year-old daughter got in an accident and became a quadriplegic. And they had to go back and put together something extraordinary to address the special needs of the child and help the mom out. And then the dad and his new wife in Colorado moved 1,300 kilometers or 800 miles back to be with the daughter. Possession schedules. You need to let people know what type of possession schedules you want, what you're entitled to, and what you're literally capable of doing. What you're literally capable of doing. You don't want to get the highest amount of relief, that is the most time with the child or children, if you live 60 miles away and you can't drop them off to school and back every day, right? And of course, here's what Serena was talking about. Summarize the pleadings of your case, that is the files that you filed with the court through the clerk's office in your county or country or province or jurisdiction, and summarize the discovery. That really helps them. Now we're back to Serena's topic in the blue column.
Yeah, so now it's especially important, obviously, those two other sections as well, but you want to summarize your interpretation of the case. Not only provide the background, but also provide the meat and bones, and starting off with summarizing your client's position. You're going to mediation for a purpose. You're going to mediation either trying to get an agreement or maybe try to check off the box before you go to trial. But regardless, you want to summarize your client's position. Make it simple, plain English, or whatever language it's in, make it plain. You want to say, this is what my client wants, and this is why, this is their position. Because simply just saying, hey, here's the facts, here are the case, that doesn't really, here are the issues, doesn't really tell the mediator what you actually want. And so you want to make sure you include that.
I want to interject something. As you know, I literally just got back from Pakistan, where my partner in Toolkit.law and our whole development team there, they all speak 4 different languages. He speaks 5. Okay. Do you think that that's important to the mediator to know what language? Right? Some people don't speak English, but in Pakistan, all laws must be published in English. All cases, all trials are in English. All law school is in English. All judges must be bi or trilingual. Okay? Let them know if there's a language barrier, right? Let them
Absolutely.
know if there's a language barrier. And what I always like to do is whenever you're going to have like a parental communications app, specify the language that they must communicate in. In the United States, I
Absolutely.
always say all communications shall only be in English. So the judge can read when that one party just says something extra special and they accidentally hit the send button. I know that's never been one of your clients. I know it hasn't been,
Never,
but
of
it's
course
certainly
not.
been one of mine.
Wow, wow.
Go ahead.
That's interesting. Touching on that real quick, that's very interesting that you're saying you specify language because you are correct. If you get a co-parenting application, it's more likely than not going to be admitted. But if it's in a different language, you are going to have to spend a lot of money to get it certifiably translated so that it can come in. And oh my goodness. Anyways, we'll come back to that too.
At
But
this
so much more.
at this Pakistani wedding that I was at, on one side of the family, half of the same family couldn't talk to the other because they didn't have a language in common.
Wow. Oh my goodness. But
Punjabi, Urdu, Pashto. I
wow.
forget what the other one
We
was.
can we can go on and on about that, but we'll
Yeah.
definitely touch base on that later. But yeah, let's come back. So going back to kind of what we were talking about, summarizing your interpretation of the case. Anytime, background information, it kind of goes without saying, but put it in there because it is helpful to put it in there. Kind of talked a little bit about key dates, kind of goes a little bit to the timeline, providing a helpful timeline, that kind of thing. Um, another one key thing that I think is really important in your mediation method, advocate for your client. Show them that you are on their team. There is nothing worse, I'm sure, than a mediator reading a memo saying, is this attorney then like on their client's side? I mean, there's always going to be times where a client does something that we may not agree with or we side with, but you still got to advocate for them. Everybody needs a chance. Everybody deserves the fighting chance. So make sure to advocate for your client. But also, you want to make sure you summarize the opposing party's claim. There
Yeah,
may be
I want to add something. If you're a mediator and a party and an attorney does a mediation memorandum for you, find a way when mediation starts, not to the embarrassment of the other attorney, but to
yeah,
let the client know that the attorney went above and beyond. In family
exactly.
law, only 5% of attorneys do mediation memorandums. You know what? It is the best, easiest thing you can do as insurance against a grievance or a malpractice lawsuit. Because not only can you show that you did what the other 19 out of 20 family attorneys don't do, you can have the mediator do an affidavit for you that, wow, this attorney, Serena, she was awesome. She did a mediation memorandum. The other side didn't do that. And it was detailed. Everything I saw was this was a fully prepared lawyer. And so not only do you have an exhibit of the mediation memorandum that you did to help you whenever you have a grievance against you or a malpractice suit, but you've now got a witness, interestingly, of the mediator. They can say they were prepared. This is what they turned in. And you just draft the affidavit for them. And the mediator's going to tweak it, sign it, and say, my pleasure to help you out because you're one of only 20 people in the cycle that helps me out with the mediation memorandum. So I'm a big believer in helping attorneys get the credit that they should.
Exactly. Exactly. No, that's an awesome point to thing to point out. So yeah, kind of going back to this, sometimes we got to have people defend us, but you know what? We got to defend others, and especially when they got skeletons in the closet. So, kind of going back to what you were saying or what we were saying earlier, of, not every case is person's perfect, not every case is as glamorous and great, but and that when there are times where skeletons need to come out, when they need to come out, when they need to be addressed, you want to address them. I'd certainly rather know something bad about my client ahead of time than know about it for the first time in court. And I think the mediator would probably want to do the same, hearing it on my side versus the other side, because the other side could completely mischaracterize it. So anytime there is a skeleton in the closet, make sure you address it. Address it head on, move on, be done with it. Kind of the opposite of advocating for your client, make sure that you advocate against the opposing party's claim. I think that kind of goes without saying, but you want to make sure that you demonstrate how your side, testimony, evidence, with summaries or anything, that you have that will go against the other side's claims, because it'll help you win your case and it'll help you in mediation. I kind of, as a little segue, or kind of tangent to this, is I prepare for mediation similar to trial. Not saying that I fully prepare for trial while I'm going to mediation, but I think it's really helpful because it's the best way to ensure that you get the settlement that you want, or that your client wants, or as best as you can.
I
Um,
start my exhibit list and my witness list on intake of a new client.
I start notes with that. So it's interesting, like a little trial outline. I start with that too. Text in mediation today. I was working on an outline, asking questions back and forth because I'm already the tables are turning of like, oh, what is it I have to do, or this or that. Like there's so many moving parts of a case. You don't go until the last minute to prep it. No, you want to make sure that you work the case. That's what they call it, working the case.
And, and,
Working.
and the other thing is, it'll be a good bit more work, but it's
Yes,
work for which it is appropriate that you bill,
yes.
right?
And the
Because if,
clients appreciate it.
yep. And when the mediator says, hey, just to let you know, Serena did this, the other side didn't. I already
Yep.
reviewed it 2 days ago, and let's hit the ground running. And I'm so glad she listed what you guys have already agreed to, what won't be an issue. And then she highlighted what needs to be resolved. And so let's
Yeah.
just jump into that right away.
Yeah, absolutely. You just kind of touch base on that. Like if there's any issues that are not likely to be resolved, include that too. Hey, or hey, mediator, we realize that this is an issue. We don't think it's going to be resolved necessarily either now or maybe on final. But we need to it's something to talk about or something to bring up because it could be resolved. You never know. But you make just make sure to include that too. Um, One thing I do want to touch on in kind of in the next section is um, a lot of times mediation can be a very emotional process, especially in the family law world. I know this isn't just for family law attorneys in Texas. I know it's in other countries too, but I think a lot of the things that we deal with in the family law world are very emotional, and so sometimes you want to let the mediator know ahead of time what your client or what the other side is, how they're going to be, or how you think they're going to be. Because it helps to know your audience and knows how it's helpful to know how to handle some different personalities, and letting the mediator know that ahead of time, confidentially though, is pretty key. And I find it to be extremely helpful in kind of dealing with some different types of personalities, and it's totally fine. I mean, it's the same, and that's perfectly fine. But you want to make sure that you're again playing to your audience.
So
And
let's jump to, we got about 6 minutes left. Let's
oh,
jump to this last column.
yeah, let's do it.
Summarize your realistic offer. So when you meet with your client, first of all, explain the process to them in advance.
Yes.
Explain explain that it's confidential. Explain that it can't be recorded. Explain that they can't text behind you to the other party while you're mediating, thinking your client's just talking to you,
Yeah.
especially if it's online. Oh, the times I found out that my client was messaging the other party when all four of us were at four different Zoom locations dealing with the mediator, darn frustrating, right?
Happens all the time.
Tell your client the do's and the don'ts, what's realistic. I tell them, if you want justice, that's a trial and you can't afford it. But if you want to do mediation, that's like a used car deal, and no one's going to be happy when we walk off the lot. My boss will say, why did you sell it for that low? Why didn't you get more money? And when you go home to your spouse will say, I can't believe you paid that much. But about 30 days later, it'll settle in, and it was something that the parties could live with. Help them face, expectations versus reality, right? I had someone who was a methamphetamines addict. They wanted to be the custodial parent. Well,
I've had that too. I've had that too. We all have them. It does happen.
I think that client probably fired me and then went and hired you. I don't know. But, to set their expectations to be realistic.
Yeah.
Okay. And I like how you said have the client review the offer. I would send them the mediation memorandum with the exhibits and say, what do I need to change? Do you approve this? That way I get credit and they can see the extra work that I did.
Yeah.
And I'll tell the mediator, if I'm not mediating, I'll tell the mediator, hey, how often do you get mediation memorandums? Well, if it's an area of law in which it's not that often, say, hey, would you mention that to my client when you pull us off in a separate room? Just let them know I went above and beyond. That's not unfair. And it's honest. Okay.
It's true.
Do
Yeah.
get creative. Okay. Remember, people learn three different ways: by seeing, by hearing, or by doing. I'm a 100% um, kinesthetic learner. I learn by doing. And so when I read that memorandum, I literally sometimes I will stand up and act it out in my office. Or when I'm talking to a mediator, I'm thinking, are they an auditory, a visual, or a kinesthetic learner? I use my hands a lot to try to figure out how they learn. Because if you're trying to show something to someone who's an auditory learner, they're only getting about 5% of what you're trying to communicate. Obviously, summarize your offer, provide a reasonable offer, though there's also the side that says if your first offer doesn't insult, it wasn't low enough. It depends if it's a civil case versus a family case, because in that civil case, you may or may not see those people again. But if it's a family case, you're only going to be great grandparents for the next half century together, and you're going to be at barbecues and weddings and funerals, and you're going to have to live interacting with that person. So think about how you put together an offer, make it realistic. Other issues to be resolved, provide a list if there's something unusual. I'll never forget, Serena, a wealthy couple, no children. They had a dog that was 16 years old that was dying of cancer, and they were fighting over who got to spend the last 2 months with the dog, and it almost didn't settle. It almost didn't settle. It was crazy.
I don't know. That seems a little bit more reasonable than in one of my cases where they were fighting over a $3,000 fish tank. And old DVDs. I forget about that one.
Okay.
So, yeah.
So remember to prepare and provide a backup offer and have it discussed. Let them know they're going to give an offer. Don't freak out.
Yes.
Don't freak out. But also, when you share pieces of evidence, it needs to be the kind that changes the dynamics of the mediation. I jokingly say in Latin, it's the sanctus cacas, the holy shit piece of evidence that makes a mediator go, holy shit. I'll never.
Everything.
This is my favorite one. It was a family law case. They showed me a video of the man, the husband, and many jurisdictions won't like this, but some countries you can go to places where people are naked or partially naked. And this person was at an event having sexual favors performed on him. And the mom, the wife, the attorney showed it to me. I said, I just need to see it for 3 seconds. Okay, I can see it. Great. I go into the other room to change their world, right? This earth-shattering evidence. You want to be custodial parent, but you're engaged in this. And he goes, do you know who shot that video? My wife. She was there with me. And she didn't even bother to tell her attorney that she was the one who shot it. So then we go back. I said, attorney, I got something special to share that didn't have the impact that you thought. Ask your client who shot the video. She goes, oh, I shot it. Yeah, I was there. We go there all the time. Talk about parents of the year. Let's go ahead and wrap this up. Okay. Great. So prepare and provide a backup offer or counteroffer and set expectations, right? Include calculations and provide specific provisions in the offer, right? Yes. If this is done, then they'll dismiss their case, or they'll non-suit something, or they'll withdraw something, or they'll waive this. And it must be paid in this way. But if it doesn't happen, then you're responsible for the legal fees if I have to come back and enforce it against you. Things like that. So we went just like 2 minutes over, but what a great memorandum you and What's David's last name? Arrington. An attorney named David Arrington in Texas did this with you. I get so many people who tell me this is their favorite help sheet in presentation.
Really?
I've had that for like 3 years.
Oh my gosh, I did not know that. That's amazing.
I told you that
I have to
once,
reach
but
out to him.
I told
Well,
you that once, but you're so
I
busy.
get
Busy.
well, I got to give him some credit too, because he and I did this. I remember this probably three, 4 years ago. We did this together and collaborated on it. So yeah, I got to give him half the credit for sure, because he was very helpful. Like we both were like, okay, what is it that we actually would want? What is it that we actually do? And just make sure it's all in there for everybody.
Do you remember you did a template, a Microsoft Word template that went with it? I still have this on
I
my
do.
on my mediation business at tomking.com in my resources section. I have your help sheet and your Microsoft Word template, and attorneys download it, they read the help sheet, and then they use the template.
It's so helpful because it just breaks it down, but it's all right there. You reference it. It's not just like, 4 pages of just paragraphs. It's broken up. You can see it. You can go straight to it. It's again, playing to your audience. How can you make it easier for the person who's dealing with this to be able to just pick it up, run with it, and address it?
Attorney Serena Hudson, thank you again for your help. And this
So
concludes our session on mediation memorandum drafting.